I apologize to the court.
I called the Suarez case.
Yes. Good morning, Your Honor. Marcia Crater on behalf of Mr. Suarez.
All right. He has already identified himself. What are we doing on this today?
Your Honor, I've had conversations with Ms. Hughes and we're in agreement. A 2-week adjournment would be advisable for further plea negotiations and me having the ability to actually meet him at the MDOC.
Probable cause conference in this matter will be adjourned February 15th, 2024, 9 a.m. Bond will continue on this matter. Thank you. Yes, hold on.
Joe.
Okay, Mr. Suarez, nice.
Oh, I'm sorry.
He left. I'm sure it was something you said, but go ahead.
If we could charge this adjournment with the defense, please, because we did receive 180.
Right away, you can tell this courtroom isn't wasting any time. Routine scheduling may sound simple, but every delay has a legal purpose. Whether it's reviewing evidence or negotiating a plea, these short adjournments can completely change the direction of a criminal case. Keep an eye on the judge's reactions. They often reveal more than the words themselves.
180-day notice on this.
Okay.
Thank you.
I will indicate that it's defendant's request. Thank you.
Thank you, Your Honor.
Thank you. Let's call the case People versus John Boyer.
Good morning, Your Honor. Robert Ellman on behalf of Mr. Boyer. Your Honor, I will keep my antics to a minimum, but there are some things that I do need to say.
Oh boy, here we go. Go ahead.
Your Honor, Mr. Boyer is present over Zoom. I do know that he was supposed to be here in person. He knows that as well. I have talked to him about the importance of being here in person. However, he was unable to find a ride to court today. It was my intention this morning to ask for an adjournment of this PCC anyway, because I...
Preliminary examination will be set in person, February 13th, 2024, 9 a.m. That is before...
I believe
Here's where things become serious. Missing a required drug test or failing to follow bond conditions might seem minor, but to a judge, it's often viewed as ignoring a direct court order. One small decision can quickly snowball into losing your freedom. Would you risk everything over a single missed requirement?
indicate she did show up.
She didn't test.
I didn't have the money to test.
They would have tested you. You didn't report. You did not report back to test. What did I tell you?
To call the next day.
What did I tell you the last time? I said no more missed tests. Remember me telling you that? I didn't hear a response.
No, I don't remember you telling me that.
You don't?
No. Because I hadn't been there. So you told me I had to go over there. I didn't have the $12. They were there with me. I didn't have the $12 that day. And she said to call her the next day if I could get there.
And did you call?
Yes. I told her I didn't have the money to do it.
You didn't report. I don't know that there's much else to discuss. Ms. Crater, what do you want to do with the proceeding?
Your Honor, at this point, Your Honor, I would request an adjournment of the PCC in this matter to see. I'll just request the PCC be adjourned for as short as time as possible, Your Honor.
Will be adjourned to next week, February 8th, 2024, 9 a.m. Anything you want to say regarding bond?
Your Honor, my client does have support in the community. Avalon Housing representatives are here. They have supported her. She did.
Would have helped her arrange for testing.
Avalon has reported to me, Your Honor, that they are not able to financially support her as far as that goes. She did go over to community corrections. She completed the intake and was put on a random indicator according to the report. She was, as according to the bond violation report, she was instructed to submit. She stated she did not have the money. She was, okay. And she was told to
Whoa,
submit,
whoa. Look at the next line.
she was instructed to return the next day. That's what I was going, is that the line you're
In the
referring to?
next sentence, and she
She
failed
failed to
to
be
do
there.
so.
She told me just to call if I couldn't.
There has been no contact with Ms. Roper since intake.
The report is,
Watch this closely. The judge isn't just listening to explanations. He's comparing every statement against the written violation report. In court, documented facts almost always carry more weight than verbal excuses. This is the moment where credibility can either save a defendant or completely destroy their case.
accurate on that, Your Honor.
Anything else you want to say?
Your Honor, I'm concerned with if she's incarcerated, her ability to continue with services through Avalon Housing.
Ma'am, I told you to appear, and you had 2 previous missed tests. You gave me the story the last time. I was serious about your reporting, and I told you no further missed tests. You missed the test. You didn't do it. You didn't even cooperate. You didn't go back in terms of even follow the instructions that they gave you going back. Defendant's bond is hereby revoked. Defendant's remanded. Pardon?
Your Honor, I came in on a different case, so I wasn't aware of the bond violation.
I'm in 23-2, 17-3.
1738.
Yes.
Judge, it does indicate that he was ordered to report on the 14th, and it appears he hasn't reported yet. I would ask the court just to allow his bond to remain with the instruction that he go report to community corrections right now.
Why didn't you report?
I didn't even know. I just got out of jail like 2 weeks ago.
I need 2 orders. Okay, I'm going to order that you report over to community corrections for testing. For intermediate supervision, testing once per month. Understand that? So before you leave the premises, you need to go over to community corrections. I'm going to sign the order on that. You understand, sir?
Yes, sir. I have a question.
What is it? I don't want to talk directly to him.
This is actually a second chance in action. Instead of immediately punishing the defendant, the judge gives clear instructions to report to community corrections. Judges often prefer compliance over incarceration, but only if the defendant follows through. The next move is entirely in his hands.
Your Honor, he doesn't currently have an ID.
Where is your ID?
I don't have one. I have an appointment next week at the Secretary of State to get it.
Tell them I believe he can use his booking photo. So tell them that over at community corrections that you don't have an ID, but that you just came out of jail. They may be able to get an ID on that.
All right.
Good morning, Your Honor. May I please this honorable court, Rita Young, P44626, appearing on behalf of Ms. Tanisha Moore, who is present. Ma'am, would you state your name for the record? Tanisha Moore.
Fine. Thank you. All right, what are we doing?
Requesting an in-person preliminary examination hearing, Your Honor.
Discovery is complete.
Yes, I believe so.
People have their witnesses on the 13th. Preliminary examination, February 13th, 2024, 9 a.m. That's in person before judge, fresh hour. Thank you. No, it's okay. They're good.
Thank you, Your Honor. May I briefly address bond?
You may.
Thank
Briefly.
you. Okay. Excuse me. Ms. Moore's bond is currently set at $5,000, 10%. She is requesting the court to consider reducing it to a personal recognizance. She is 28 years old. She lives on Pearl and Ypsilanti. She lives alone at her residence.
Go ahead.
She reports that she has no prior felony convictions. She does have a pending misdemeanor, which is scheduled for sentencing on February 22nd, and she is on a tether relative to the misdemeanor. So she's asking the court to please consider a personal recognizance bond with respect to the matter before this court, and she will appear for all future hearings as required.
Response?
I believe on reference by Ms. Young is appropriate given the case as
Was she on pretrial release when this offense occurred? Or under sentence?
I did not note the date of the misdemeanor. She's not sure, Your Honor. If we could pass on this matter, I could pull up the other case, the pending misdemeanor, to see.
Well, this occurred in January.
Okay.
So how long have you been on a tether?
Oh no, I'm supposed to get a tether if I get released today.
Pardon?
I'm supposed to get a tether if I get released today.
I thought you said you wanted tether from Judge Washington.
No, I was on a tether from Wayne, but when I got incarcerated here, they cut it.
So
Washington ordered me a tether, but I couldn't get on tether because I had to go to Wayne, and Wayne gave me tether, came back. But she ordered me a tether, my last case.
But the question is was the misdemeanor before this case?
Oh,
it was?
Yes,
So you were on release when this case occurred?
correct.
Motion for Calls the case of the People versus Isaiah Baker.
Prosecuting attorney Logan.
Good morning, Your Honor. Joy Gaines, Senior Assistant Public Defender, representing Mr. Baker, who's appearing.
Bond decisions aren't based on sympathy, they're based on risk. Once the judge realizes the alleged offense happened while the defendant was already on release, the chances of reducing bond drop dramatically. Prior compliance matters and previous court supervision can heavily influence every future decision.
Who's appearing by Zoom. Sir, would you please state your name?
Isaiah Baker.
Your Honor, at this time, Mr. Baker is requesting a preliminary examination.
Discovery complete.
That is my understanding.
People have their witnesses available on the 13th.
Yes, Your Honor.
Preliminary examination in person, set February 13th, 2024, 9 a.m. before judge for information, but the jail has.
Police report everything. I'll come and see you, okay?
Okay.
All right, thank you. Your Honor, I'm going to file my appearance for the record.
Very good. Bond will continue in this matter.
Thank you, Your Honor.
Thank you. Court calls the case People versus Reginald Elliott.
We have a case number, Your Honor.
That's case number 23 F5 5244.
Good morning, Your Honor. I'm Special Assistant Attorney General Mitchell Wood for the People.
Kenneth Overwater, Assistant Public Defender, appearing on behalf of Mr. Elliott, who stands to my right. Mr. Elliott, would you state your name for the record, please?
Reginald Elliott.
Your Honor, it's the date and time for a probable cause conference. This time, my client wishes to waive his right to a preliminary examination, have the matter bound over to circuit court.
Sir, is that a correct statement? Take your hand out of your pocket. Yes. Correct statement. You understand that a preliminary examination is a proceeding where the people have to show by probable cause that the offense alleged was committed and it's committed it. Yes. You understand you'll not have that hearing. You'll proceed to circuit court for further resolution. Yes. People also waive their right.
We do, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on a single count. Mr.
Your Honor, I'd waive formal reading. I acknowledge receipt of the information. My client would stand mute.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
March 11th at 1:30 before Judge Slade Monday.
March 11th, 2024, 1:30, Slay Monday.
That's yours.
Bond
Your
will
Honor.
continue in this matter.
Your Honor,
Thank you. Yes,
Judge,
sir.
If I may, there was a matter of bond, and I
Yes,
don't
sir.
know if you entered an order. The defendant made bond and he agreed to pay it over. I don't see that it's done, that's happened. It was back on January 18th, and I don't know, I know you've got a mechanism to make that happen quicker.
We
Otherwise, they
do, but let me. I don't know if this is one of the older ones. No, we have in the file when he was arraigned before the magistrate that if bond was posted, it was to be applied to case 2009-0003 or yes, 000399 DP. So it is ordered. What I will do is
This may sound routine, but waiving a preliminary examination is a major legal decision. By doing so, the defendant moves the case directly to circuit court without challenging the prosecution's evidence at this stage. Sometimes it's strategic, sometimes it's risky, but either way, the stakes just became much higher.
will have my staff check on that. We'll send an email over to see if we can get that applied to the case.
I appreciate it, Judge. Otherwise, we can do it in circuit court as well, but sooner the better. So thank you very much, Your Honor.
Thank you.
Thank you, Your Honor.